My name is Carrie Scott. I work at Spruce Health. I'm going to be serving as the moderator for today's event so that I can help guide the discussion in a meaningful way and make the best use of our guests' time. With that, we have an incredibly exciting agenda for everybody today. I'm going to just kind of quickly introduce Spruce to those of you on the call who are new to us. I'm going to give a brief overview of our guest speaker today and let her touch quickly on her practice. And then we're going to get into the meat of today's discussion and talk through everything from state statutes around telehealth to breaking changes in the industry that could affect you. We are going to leave time at the end for questions, so please have yours ready. Encourage you to drop them into the Q&A. I have Jessica Gulish, my head of sales at Spruce, on the call with us today as well. She will be here to help answer anything Spruce related. So don't hold back. Anything for Kathrine, for Spruce, we're going to get it all tackled. And with that, I'm just going to get us going. So for those of you who are new to Spruce, Spruce is a healthcare communication platform designed for medical professionals and easy HIPAA compliance, which is going to be a big part of our conversation today. It does consolidate communication channels, including a business phone line, fax, text, and telemedicine into one unified cloud-based solution. And the image that you see here on the screen is a great visual representation of what Spruce actually does and gives you a good look at the interface, which is nearly identical across devices. So that's the nutshell. But if you have any questions, be sure to drop them in there. With that, I want to get right to the good stuff here. Kathrine Nicol is joining us today. She is a well-known healthcare regulatory attorney. She brings both in-house and outside counsel experience, guiding healthcare facilities, physician practice groups, and individual practitioners through ultimately a maze of the regulations that these folks face today. We have partnered with Kathrine. We're so lucky to have her to bring you all a breadth of information on the subject of telehealth. Kathrine is going to illuminate us with some of the finer points that should really remain top of mind if virtual visits are a part of your practice. Now, again, just to kind of reinforce my role here, I'm going to be hanging out in the background. I'm going to be checking the chat and the Q&A for any questions that do come in. So, please send them in as we go, as you think of them, but we'll tackle them at the end. We aren't going to be able to get too terribly granular about your specific situations today, but we'll happily answer anything that's going to help the group at large. And then when we get toward the end, Kathrine has provided her email address so that if you want to reach out and contact her directly, you can do that and maybe set up some time to get more specific. With that, I am going to just hand the baton to Kathrine and let her say a quick hello, talk to us about Nicol Health Law, and get this incredible session going. Thank you for being here, Kathrine.
Thanks, Carrie, for that introduction. So a little bit about my practice. As Carrie mentioned, I have experience both as in-house counsel for a group of hospitals that were based in Texas and California. They were physician-owned, for-profit hospitals, so I'm very familiar with the nuances and intimate regulations that affect physician-owned for-profit practices, which most of the people on this webinar are. I also understand, some of the specific delivery models like direct primary care, concierge, and telemedicine practices, which are very different. And I also understand and can provide legal services if there are investors or non-licensed individuals who want to have an ownership interest in a business that delivers healthcare. And if that is what you want to do, you have to be very specific and careful about not violating the corporate practice of medicine and have a management services organization. So, and then I do a lot with, transitioning practices, representing physicians who want to sell their practice. I'm doing a lot of that right now with a lot that's going on with One Medical, Village MD, Optum, that kind of thing. So, yeah, kind of the whole host of what I do.
Thank you for that, Kathrine. I'm going to just move us right into the good stuff and let you take it away.
Okay, so let's get started. Just real quick, this isn't legal advice. So as Carrie said, please get in touch with me if you have any specific questions, but this is just general. We always have to do this disclaimer. So the first thing you want to do if you're going to be providing telehealth is to make sure your malpractice carrier covers you for telehealth. Some carriers include coverage, others require you to have supplemental coverage that's purchased, but you need to reach out to your malpractice carrier, make sure that you are provided. You also, if you're going to be offering telehealth in more than one state, confirm that your policy covers you for all locations. And this is super important. So do have that conversation with your carrier and explain to them what your process is for telehealth and make sure you're covered. Okay, so now let's talk about some of the state statutes. You need to get licensed in the state that you will be providing telehealth. It's just a general requirement. The COVID public health emergency waivers that were issued by 38 states that enabled doctors to provide virtual visits to residents of other states have expired. And they are going to be expiring October 13th. If some of them, others have already expired. So check if the state in which you're providing interstate telemedicine allows the provision of interstate. So for instance, Virginia provides licensed reciprocity, allowing telemedicine to be provided to residents of Virginia by bordering state licensed physicians. So if you're in a border state and you want to provide telemedicine to the residents of Virginia, you could do that. Other states have similar statutes, so you just need to make sure, do you need to be licensed in that state or will they allow this reciprocity? Florida has established a telehealth registration for out-of-state physicians. So if you want to provide telehealth to the residents of Florida, you need to be registered as an out-of-state provider with the state of Florida. By the way, the requirement to be registered is not needed if you are a Florida licensed physician. There's also some exceptions for peer-to-peer consultations, but they have limitations as well. So for instance, if you are not licensed in the state of Minnesota, but you're contacted by a Minnesota physician for a peer-to-peer consult, you can, as an out-of-state physician, provide telemedicine, but it's limited to less than once a month or to less than no more than 10 patients per year. So other states have other requirements, so you need to check with that as well. Okay, so now let's move forward with HIPAA compliant communications. All right, so you got to make sure that the channel that you use for patient communication regarding PHI, protected health information, is HIPAA compliant. What's acceptable according to the security rule and HHS are landlines for audio only, but what's unacceptable is FaceTime, Zoom, Skype, or voice over internet or cell phones. These are not HIPAA compliant. Now, obviously, if you use Spruce on your cell phone, that is HIPAA compliant because they have encrypted everything, so you can use your cell phone for communications. But if you're just using your AT&T or Sprint or something else like that, that is not going to be HIPAA encrypted. So you need to understand that, once again, the Office of Civil Rights, the enforcement discretion and waiver of penalties for non-compliance is scheduled to end October 13th. And the OCR, the Office of Civil Rights, will resume enforcement actions and penalties going forward. So you have to make sure that if you started your practice and you were using Zoom or FaceTime or Skype, that time has come to an end and you need to get compliant with the security rule and use Spruce or some other form of HIPAA encrypted communications. Couple notes here: an individual receiving telehealth services may use any telephone system they choose and is not bound by the HIPAA rules when doing so. So it's not on their end that you have to be worried about, it's your end as the provider of telehealth. Also, a covered entity such as a healthcare provider is not responsible for the privacy or security of individuals' health information once it has been received by that individual's phone or other device. Okay, another thing that you need to have in place are business associate agreements, BAAs. Make sure you have a BAA in place with any third-party entity that is storing electronic personal health information created by you on your behalf. So for example, your EHR system or your billing system. Now, obviously, Spruce does have a business associate agreement that it enters into with every entity provider that uses Spruce. And I believe Hint and some other software and billing platforms have that as well. But whatever you're using, make sure you get a BAA. Okay, so another important part is what's the difference between consent versus authorization? And I see this a lot. So consent is not required if the uses and disclosure of PHI is for treatment, payment, and healthcare operations. So you don't need to get a consent. But authorization is required when the uses and disclosure of PHI is not otherwise allowed by the rule. And I think most providers are familiar with the authorizations. Each state has their own requirements, and a lot of the bigger hospital systems will have like a template authorization that clicks all the boxes and complies with the state rules. Like for instance, sexually transmitted diseases and addiction, health and therapy. There are restrictions on whether a patient will include that when they transfer their medical records to a different provider. And that's typically what's in these authorizations. But what's not allowed, and I see this in a lot of DPC membership agreements, is if you join my DPC practice, you consent for me to use non-encrypted means for communication. And that's built in to the membership agreement. You can't do that. You can reference that if a patient chooses to use unencrypted means, that they have the right to consent, and that is something that they choose. But you can't make it a condition of joining your DPC practice. So it has to be a separate consent. And then there's also some limitations on that. So HHS says that you can use unencrypted like emails for appointment reminders, or to communicate with the patient about appointment reminders. But what you can't do is just say, oh, here's an email with all of your lab results about your sexually transmitted disease. That's a no-no. So, it's very important to understand the difference between consent versus authorization, as well as what's going to be allowed by HHS when communicating in unencrypted means, like through emails. All right, so let's now start talking about some limitations that can lead to malpractice. So informed consent is super important. 47 jurisdictions include some sort of informed consent requirement in their statutes, administrative codes, medical board guidance, or Medicaid laws. And the informed consents are required before you perform a telehealth encounter. And patients at a minimum need to be informed about the limitations of treatment through telehealth and must be provided with alternatives. And if I'm drafting a DPC membership agreement or concierge, I put language in the membership agreement stating that it's up to the sole discretion of the provider whether a telemedicine visit is appropriate for the particular instance, because the providers need to understand that, of course, there are times when you don't want to have a telemedicine visit and it's not appropriate. And that patient needs to understand that you can end that. But if you don't have that language in the agreement, it could lead to some form of malpractice, because the patients may have expectations that they never have to come in and see you, or you're ending a telemedicine encounter abruptly. So remember, it's your license on the line as the provider of these services, and you need to make the determination as to what you can handle in a telemedicine encounter and what you can't. And you need to have all of this put in the informed consent. Also, you need to be aware that state laws come into play here. So you need to comply with the state law for informed consent. So if you're providing telemedicine in several different states, you need to make sure that that informed consent covering that particular patient follows the statute rules. Kentucky is really interesting. It has some of the most robust informed consent requirements of any state. And it's not necessarily the laws in the statute in Kentucky, but the Kentucky Medical Board. And as a matter of fact, the Kentucky Medical Board requires that details on security measures taken with the use of telemedicine technologies, such as encrypting data and password protected screensavers and data files, are put forward in the informed consent. So you need to make sure that you're tracking all of the language that's required, not only for the state statutes, but also the medical boards of the particular state in which you're providing services. All right, so now let's talk about provider-patient relationship requirements. Make sure you comply with your state's treatment modality requirements for the creation of the provider-patient relationship. Each state is different. Excuse me. For instance, Arkansas requires a history and either an in-person physical or face-to-face exam using real-time audio and visual telemedicine. And Texas and a lot of other states are very similar. You can't just have audio only. You need to comply with the requirements to establish a physician-patient relationship. And if you already have an existing patient relationship, physician-patient relationship, you don't have to comply with the visual audio real time. But there are certain restrictions on how that relationship can be established. And it cannot be through an internet questionnaire or an email message or patient-generated medical history or audio-only communication, text messaging, or facsimile. So the big concern here is for providers who are being hired as a part of like a teledoc or some sort of system like that. You need to make sure that the company that you're providing telemedicine services is complying with the laws of establishing provider-patient relationship. And this is because that you as a provider don't have an existing relationship with that patient. If you're a DPC or concierge or whatever, and you're just adding this as another benefit to your patients, you already have an existing patient relationship. But if you're just establishing the relationship with the patient for the first time, you need to make sure that whatever laws are in that state the patient is located, that you've complied with those requirements. Okay, along those lines, there's also patient identity verification requirements. Once again, these are in the state laws regarding how you identify and verify the requirements in advance of providing a telehealth visit. So for instance, Maryland requires telehealth practitioners to develop and follow a procedure to verify the identification of the patient receiving the telehealth services and confirm whether the patient is in Maryland and identify the practice setting in which the patient is located and identify all individuals present at each location and confirm that they are allowed to hear personal health information. Now, that is what Maryland requires. And I recommend to all of my clients that no matter what state you're in, that you develop your own protocols and procedures to do these things. Because even though that particular state may not say you're required to verify, most states do, and certainly payers require that you verified the identity of the patient receiving the telehealth encounter. Another point is the Oregon Medical Board states that telehealth providers must verify the location and identity of the patient, provide identity and credentials of the provider to the patient, and provide the identity and credentials. Double that. So you got to provide the identity and credentials of the provider. So there's something more than just getting verification of the patient, but also you as the provider and anyone there has to provide your credentials. Okay, next one. Okay, provider credential disclosure requirements. So this is also something that's required by a lot of states. Make sure you comply with the credential disclosure requirements and the payment responsibility and follow-up record requirements. So once again, Arkansas is a good state to point out that they require patients to provide patients with access to information identifying the telehealth physician or PA in advance of the encounter, including licensure and board certification, as well as patient financial responsibility information. So Arkansas takes it even further than the other states, saying, look, not only do you have to provide the credentials, but you also have to provide information regarding patient financial responsibility. I know that CMS and Medicare requires this for all telehealth encounters, that you provide information about whether the patient's going to be responsible for any payments. Also, here's an interesting point. In Kansas, when a patient consents to receive care via telehealth and has a primary care or other treating physician, the person providing the services is required to send within 3 business days a report to that primary care or other treating physician discussing the treatment and services rendered to that patient. And I believe Texas has similar requirements where you have to communicate and find out if that patient does have an existing relationship with another provider. And then you must communicate whatever services or prescriptions or whatever that you have suggested to that patient with the primary care provider. So make sure you're complying with that as well. All right. Telehealth documentation and record requirements. Make sure you comply with the state law telehealth documentation and record requirements. Each state has its own content and format requirements, but in general, you have to document, the documentation must be retained in a patient's medical records and must be as detailed as an in-person office visit. So once again, Texas requires the distant site provider and the established medical site to document and maintain the records created at each site unless certain exceptions apply. Iowa requires complete, accurate, and timely medical records maintained, including all patient-related electronic communications, records of past care, physician-patient communications, labs and test results, evaluations and consultations, prescriptions, and instructions in connection with the use of telemedicine technology. So once again, we're talking about your documentation and records that you're required to keep as part of the telemedicine visit that you have provided to a particular patient, and you need to make sure you're complying with the state laws.
Well, I gotta say, that was an incredible amount of content in a very fast amount of time. So congrats, Kat. That was terrific. And
well, I know it's like drinking from a fire hydrant. So that's why we've got some time for questions.
Well, and it's good that we do have time because we do have some great questions that have come in. So without further ado, I'm gonna jump in there and field some your way.
Okay.
Now, you may or may not be able to answer this off the top. And if it's something that we've got to dig into, I can circle back with folks and include it when I send out the info after the event. But I've had a few people ask if there is a good website with updated regulations regarding telemedicine state by state. Is there anything like that that exists that kind of rounds it up for everybody?
Well, so the Federation of State Medical Boards has a very good, I think they update it like every 6 months or so, and they have a lot of information that's like state by state, but it's sort of specific about, the public health emergency waivers and interstate licensing and so forth. So it's not going to be the best place to get everything that you need. And I am not aware of any website that will give you everything that you need. But I think that that's a good place to start. I would definitely start with your own state's medical board and see what they have, and then look at the Federation of State Medical Boards, especially those states that are part of the compact. And they have a tendency to kind of lump all of the states in the compact together and what their requirements are. So those are 2 good places to start.
Okay, that is terrific. Thank you for that. We have another question here. What if you have some patients that travel from out of state for treatment and televisits are used for complimentary consultations?
Yeah, I get this question from my clients a lot. So I have not found any court precedent or medical board precedent on this particular issue. But Here's what I believe, based on some of the states that I look at, is that if you have an established physician-patient relationship with a patient, and they're, let's just use Colorado, for example, and then that particular patient travels to Florida on vacation and they get stung by a jellyfish or something like that, and they immediately contact you because they don't have a relationship with anybody, then the way that the rules work is that is not treating a resident of another state. They're a resident of your state. You have an established physician or provider relationship. They're just traveling out of state on vacation. So they're not a resident of that other state. And that's typically what the rules, the medical board rules and the Colorado rules talk about, treating patients out of state. And so, like I said, in Colorado, and I know this specifically because I looked this up, said, treating residents of out of state. And like I said, this isn't a resident. I think it's a bit trickier when you have a physician or provider relationship with a resident of Colorado, and that person is now attending college, for 9 months out of the year in another state. And that becomes a bit trickier about whether you can say, well, are they a resident of that other state? Because they're not going to just be traveling there for a brief period of time. They're actually going to be living there. So I think what you need to do as a general rule is look at the statute and the rules in the state. If you have that physician-patient relationship and now they want to go to another state, does that state say, well, you have to be a resident here, or does it differentiate between resident or non-resident? So this is on a case-by-case basis, and I think you just need to understand, where are you providing services? Do you have an established physician-patient relationship? How long you've been treating that patient, and how long will that patient be going to a different location? And will they be a resident of another state, or will they be just visiting?
Got it. Great answer. Here's another one. And I will tell you, I know we probably have a lot of folks in the behavioral health space on our call today. So just, sort of using that as the backdrop, we had this question come in the COCM model, where the psychiatrist is acting as a consultant to a behavioral care team. Do they need to be licensed in each state? And then there's a second part to that. The psych would not be making decisions or seeing the patient directly. They would just be offering recommendations based on communication from the care team. The PCP would direct care with the recommendation in mind.
Okay, that's a lot. And I can't specifically, that's asking for a legal opinion. And I think we need to understand, are we dealing with controlled substances? What's the issue with the patient? Once again, I did discuss the peer-to-peer consultation that has the exception that I mentioned. So like that Minnesota law that I brought up that says, okay, you've got some limitations there, where you don't have to be licensed in Minnesota if you are doing peer-to-peer consultation. But remember, they limited that to, how many visits per year, and other states have similar limitations on that. So if your whole business model is, well, I'm a mental health and I'm just doing peer-to-peer and I'm not licensed, can I do this carte blanche? The answer is no. You just need to look at the state laws and see what the exceptions are and whether you're meeting those limitations and exceptions. So for purposes of this presentation, I can't just give you a general yes or no or bless what you're trying to do. If you have more, specifics around exactly what you're trying to do, please feel free to reach out to me and we can talk about what you're trying to do exactly and the states that you're doing it in.
Perfect. Thanks for that, Kat. I've had a few folks ask if you're going to have access to the PowerPoint for this presentation. Yes, you will. So when I send the follow-up email, it'll have a link to the recording and it will have the slides. So no worries there. Here's a question which could actually be a Kat/Jessica question. What about VoIP phones? And I'm guessing that is with respect to HIPAA compliancy.
I'll let Jess take that.
Okay.
Yeah, I mean, from my understanding, with Spruce VoIP phones, if you use Spruce VoIP phones, I understand how they work. And we do not store anything on the actual phones. All voicemails, call logs are stored within the Spruce system, which we know is protected. So we never forward voicemails to email because that can break security. So for VoIP phones, you're going to have to check with your provider that you use for your VoIP phones. I do move a lot of people over that use services that email the voicemails that are transcribed, which is kind of a no-no because we don't know where it's emailing it. Is it secure? Where is it in transit? There's a lot of questions there. But when you're actually on the VoIP phone calling and talking to someone, that is a carve out from within, that is not, that you don't have to worry about the phone service. It's more about where the voicemail is stored, the contacts, and the call logs. And Kathrine, please correct me if any of that is different.
No, I agree with you completely. I think the biggest part here is that a lot of providers, even Zoom has jumped in and said, oh, well, we'll give you a business associate agreement. But what you have to understand is that there's different pieces of this. So HIPAA has a privacy rule and a security rule. There's two different pieces of HIPAA, and you need to make sure that you as a provider understand how Zoom or whoever the voice, whatever channel you're going to use handles all of this. Because when you start getting into the details is when some of this communication breaks down, right, Jess? So, you're going to have some aspects that are going to be HIPAA compliant and some that aren't. And that the problem is that it's the provider that gets in trouble. The Office of Civil Rights, OCR, which is charged with HIPAA enforcement and compliance, they come after the provider. And there, certain things like not complying with the security rule is like low-hanging fruit. If you don't have some form of HIPAA compliance, and there are a lot of consultants out there that do this, they'll come in, they'll help you, especially, OCR has said that their number one group of people that they're targeting are individual primary care physician practices, because they realize that these independently owned primary care providers don't have thousands and thousands and thousands of dollars of HIPAA compliance like the big hospitals or the providers that are associated with the hospitals. So it's low-hanging fruit for them to come in and say, oh, well, let's look at your HIPAA compliance. And when you don't have, a HIPAA officer, you don't have HIPAA compliance manuals, and you basically don't show that you've done anything to even have some sort of recognition or acknowledgement that you need to be HIPAA compliant, that's when they really start issuing penalties, and they're not going to be willing to cut you any slack. So you do need to determine and do the deeper dive on the phone systems or whatever channels you're using, and have these communications with the vendors of these services and ask the questions. And that's what's great about Jess, and that is that she's very familiar with where some of these shortcomings are with other vendors. And Spruce has spent a lot of time making sure that all aspects of their communications are HIPAA compliant. And if you're not going to be using Spruce, whatever service you are using, you do need to ask those questions.
Terrific. Thank you. This is an interesting one. Oh,
I just want to add, because we got a lot of questions about Zoom, about Google Meet, Doxy, all this.
I was just going to go there. Yeah.
Yeah. And so with Zoom, I think just to summarize, Zoom, like often a lot of different systems out there, phone systems specifically that aren't 100% made for healthcare, are going to sometimes offer a non-HIPAA compliant or non-BAA option. And then they have another option, generally you pay more for, that offers a BAA. Then the second thing is if they offer a BAA, what do they say in the BAA to use it in a HIPAA compliant manner? So sometimes you have to turn off voicemail transcription. Sometimes you can't use it for certain aspects. So that's kind of what Kathrine's saying, and you need to go back and review with that vendor. So first, you just need to make sure that your plan, your subscription includes a BAA. Second, go see what's in that BAA. That's really important. With Spruce, every single customer, as soon as you sign up for a trial with Spruce, you have our BAA and you agree to it. Then we also have an entire white paper on how to use Spruce in a HIPAA compliant way. And we go over every single channel that we have and how you can use everything in the HIPAA compliant way. And we'll include that in the email to everybody that's registered for this. And the same thing applies for Google Meets or Doxy or insert any other vendor, including your EHR. I saw that question a ton too. So your EHR is going to have a BAA with you. And so you have to see, is the video telehealth platform in the EHR in that BAA? So sorry to I answer these questions a lot every day. So, but if you have additional specific questions, then, Kathrine can help. So sorry to interrupt on that.
No, that's great.
That was perfect because there is this question, and I think you answered it, which is if your EMR, which is privacy protected and HIPAA compliant, uses Zoom or Google Meet or what have you for virtual care, is that okay? But I think you just answered that by saying you really have to look at the BAA and make sure that everything is connected. Okay.
Yeah, because sometimes you're marketed to say, oh, we're HIPAA compliant. But unless you ask for the BA and unless you sign up for the specific plan, so just double check. This is all, it has to be outlined there for you.
Perfect.
Yeah, and the one thing that I'm familiar with is that a lot of practices, they're two different tracks, right? Anything that's going to have HIPAA encryption, that the vendor is going to sign a BAA, because that's what it is. The business associate agreement is between the vendor and you as a provider, and the vendor is making promises that they will protect your, the information and so on and so forth. Whenever they're making that promise to you, it's going to be more expensive. And what I have seen and encountered is where a practice didn't pay for the upcharge for the HIPAA encryption, and when they got back in touch with the vendor's like, oh no, what you have is not HIPAA encrypted because you didn't opt for that package. So that becomes problematic as well, because anything, you get what you pay for, and if there's a less expensive or a cheaper product out there, make sure that whatever version you're working with is HIPAA compliant, both the security rule and the privacy rule.
Got it. Perfect. This is a very interesting question, which you may not know the answer to, but I'm fascinated by it, so I have to ask. Does HIPAA pertain to animals? As far as I know, unlike people, pets are not protected by HIPAA, the law that guides medical privacy, because they're considered property and not persons, although there are many pet owners who would argue otherwise. Okay, like people, health information for pets and livestock collected at the vet. I get, so yeah, maybe this is coming from a veterinary office, but any thoughts on whether HIPAA protects animals?
So that's my understanding as well, although I have a dog and I believe he's a person. So I'm one of those pet owners. Yes, so my understanding is that HIPAA pertains to when the definition of PHI, personal health information, that it doesn't apply to animals. But that's a really good question. As far as what other rules are out there that would pertain to pets and animals in the veterinarian practice, and I don't know the answer to that, but that is my understanding.
Okay, thank you for that. That's fun. One question came in, is what we're talking about today pertaining to the US only, or is it global? I'm guessing it's US only.
Well, US and territories, yes.
Yeah.
So, when I mentioned the 47 jurisdictions, you've got, Guam, which is a territory, Puerto Rico, yes. So, yes.
Okay, perfect.
I have one. So we have a lot of different types of healthcare professionals on this call, from MDs, doctors, nurse practitioners, to counselors, to psychiatrists. And so is there any kind of big differences in what you've talked today about that are relevant for a doctor, but might not be relevant for a therapist or counselor?
Yeah, so there are differentiations. I've tried to hit sort of a top 10 general, but So when we were talking about the state requirements as far as verification and so forth, there's some states have different rules about how a PA or a mental health professional needs to carry on a telemedicine encounter from a physician offering primary care. So yeah, there are differences, and they are going to be in the board. So for instance, a medical board provides rules when it comes to physicians and that, but nurses have the nursing board, right? So you have to check with the board that regulates your particular profession, as well as the laws that pertain to your particular profession. And then once again, reach out to those boards and that to get guidance on, hey, what are the restrictions and limitations and requirements for me as a mental health professional or a NP or PA to provide a telemedicine encounter.
Okay, great. Circling back on a cross-state telehealth question, is there any problem if someone's existing patients are traveling out of state or they've recently moved, but this provider is still caring for them while they're getting set up with new providers?
Yes, so that's a great question. Remember, physician abandonment laws are in every state, and it's a form of malpractice if a provider, and I shouldn't say physician, I should say provider patient abandonment laws. So if a provider is providing medical care to a patient who has a chronic health condition that requires continual care, and that patient moves, then yeah, there should be this like handoff. And if you acknowledge and say, look, I'm treating this patient in their transition to another physician, then that's going to be fine, even if it's out of state. But that is a situation where the medical board and the state laws are saying, well, it's not that you're providing or practicing across the state, you're dealing with an existing patient relationship that you're helping in the transition. So you're going to be fine there because, there's a requirement that you do take care and continue to take care of a patient. Now, these are all fact specific. If you're continuing to do this like a year and a half later, and they've not, had any established relationship or they have no, they're not making any effort, they're just continually seeing you in a telemedicine encounter, then that's something different. But you need to document the medical records of that patient saying, patient is looking to find or establish a relationship with a provider in the state that they've moved to, document all of that to show that you are just doing this and caring for them in this transitionary phase.
Okay, perfect. My goodness, we have so many questions, and we're probably going to be able to keep going with them for about another 10 or so minutes. So
Okay.
let me see how many we can get through here. If a provider establishes a provider-patient relationship, does that relationship then exist for the practice at large?
Yeah, that's a really good question. So it depends on what's the practice at large. I mean, you can, I know that some physicians have done a lot of moonlighting with telemedicine companies, right? So they've got their day gig and now they're doing their moonlighting gig where they're doing, telemedicine. And then, well, now we've got a situation where that particular physician the patient doesn't have a relationship with the practice, right? The relationship is between that physician and the patient. So, I think it matters in the context of what is the telemedicine encounter? Is this if it's a physician-patient relationship, and there's, what is the contract, right? Is this a DPC or concierge practice or a mental health? What is the agreement between the patient and the provider? What are the expectations? And then what is the context of the telemedicine encounter? And that will really sort of establish, what is the expectation of that patient and the practice. So I think I would need more facts to be able to give you a better answer, but I think you generally understand where this is going. Like what is the contract and the expectations that the patient has for either that telemedicine encounter, or is it built into some sort of other membership agreement or something like that? I hope that answers the question as best I can.
Yeah. I think that was great. We'll see if we get a follow-up to that. Here's one. So for consultants who offer recommendations as opposed to direct patient visits, do they need to have a face-to-face exam prior to offering recommendations to the treating provider?
Well, once again, this goes back to that peer-to-peer, right?
Okay.
So, you've got if it's peer-to-peer, you're basically, I guess this is a licensing question. So there's one issue is, do I have to be licensed in that state for peer-to-peer? And we've already talked about that. But then the other issue is, consultants and, to what extent do you have liability, and what are the requirements of the telemedicine encounter? And that's going to be answered by your state laws and your medical board, right? So if you're are you required to see that patient or treat that patient in a telemedicine encounter if you're just doing a consulting? Well, no, that's what peer-to-peer is. So I guess I'm a little confused on the question and want to understand what we're talking about. There's one lane about what are the requirements for peer-to-peer and the documentation of a telemedicine encounter for peer-to-peer versus, to what extent can I provide advice on that patient, and am I required to see them in person and, audio only or audio visual? And that's going to be, once again, addressed by the board that governs your practice or your licensure, as well as the state rules.
Okay, got it.
Does that make sense? I hope.
Yep.
I think I did. Okay.
Yeah, I think so. And then too, I feel like you probably covered a lot of that in some of your earlier answers, but as you can see on the screen here, if somebody wants to follow up with you, they certainly can if we miss something here. Here's a question. Are the laws the same for telehealth via mental health counseling professionals versus healthcare or medically licensed professionals?
They're different. Well, so like I said before, each state and the board will basically say, here's what's required for a telehealth encounter. And then they do differentiate between the provider and what services you're going to be offering. So yeah, you can't just say, oh, well, I'm just providing mental health counseling and I don't have to comply with telehealth because this is just, for primary care. That's not true. You have to look at what is specifically required of you and have to be aware of that. And the whole point of this sort of top 10 was for you as providers to go back and think about these things. Like Carrie said, you're going to have access to them. And so every single time you look at one of the slides, say, okay, this is what I'm doing specifically. I'm a mental health counselor, or I'm, a nurse practitioner, or whatever you're doing. And you have to look at, okay, well, here's, what are my requirements for credentialing? What are, do I have to provide that information to the patient? So yeah, they're going to, some states, it doesn't matter. They don't differentiate between what services you're providing, and other states do. They may have more specific requirements. For instance, if you're doing mental health, and I know that for that mental health has a lot more specifics because it is so different from, providing primary care, especially if you're dealing with, addiction counseling and so on. So you do just need to, like I said, go back, look at the board that controls your licensing and look at the rules in your specific state.
Okay, perfect.
And like I said, too, is, like Kentucky, I use that as an example for a reason, is that Kentucky has a state law that is a lot more liberal when it comes to what requirements need to be in a telemedicine encounter for informed consent. It's the Kentucky Medical Board that puts even more robust, onerous requirements on providing a telehealth encounter. So that's why I said, look to your board rules, because that's what controls your licensure.
Okay, that's great advice.
Okay.
Do you know off the top if there are any laws pertaining to recording a telehealth visit?
Ooh, that's really, so are we talking about store and forward, or are we talking about you just recording your encounters? So I do know that there are rules for store and forward. I do know that some EMRs are able to capture certain information from a telemedicine encounter, but I don't know whether there's a state with a specific rule that says you can or can't record a telemedicine encounter.
Okay. Okay. Well, that sounds like they need to maybe just dig in a little bit on that one. So thank you for that. Here's a quick one for Jess. Jess, this person is saying that they have grad students and they're wondering if there's a way for them to be present in a telehealth appointment on Spruce.
No, right now, Spruce telehealth or video calling specifically is only 1-to-1. So you would all have to be in the same room as the provider team calling the patient. So we don't do group video at this time. However, they can be involved in, if they're grad students and they want to view messages from the patient or call or receive calls from your patients or clients, you can share a phone number within Spruce really easily. And you can also group message different patients. So a lot of times that happens when you have couples or parents and you want to group message them with, kind of the protocols and plans, but no group video at this time.
Do remember from a legal standpoint that you need to get permission from the patient to when you have all these grad students. So just like if you were doing an in-person visit and you want to bring these students in, medical students, whatever, grad students, and say, hey, these are students, do you mind? Would you consent to them being here and present while we conduct this examination or whatever? Because you do need to have that permission from the patient. And like I mentioned in one of my slides, there's a state laws that require that you get consent and know who's in the room and make sure that you've addressed that in your records.
Perfect. Thank you both. Are there any specific considerations for prescribing across state lines?
Prescribing.
So it says, assuming you are licensed in the state where you are providing care and sending prescription.
Well, just because you're licensed in a particular state. Oh, so I guess, you can imagine a situation where you are treating a patient that is your patient, right? So we've already established you have a physician-patient relationship, and they're like, let's go back to the example of Florida, right? Where a patient is traveling and, has, I think I used stung by a jellyfish or something like that. If you need to write a prescription, you can write a prescription. I guess the issue is, that's a federal law, the DEA license to write a prescription. So that prescription is going to be acknowledged by the pharmacy that fills that prescription. So, I think that's the big issue. I'm not aware of, I guess I would have to know exactly what they're trying to do. I think it would be different if you're, what is the context? Is it controlled substances? I mean, what are you doing exactly? I mean, it's one thing to write a prescription for, bisoprolol or something like that, which is a heart medicine that people need, constant thing, and they need a refill and they're out of state. That's one thing versus what's going on here, maybe something different. So I think I need a little bit more facts to be able to give you a definitive yes or no.
Okay. All right. Good answer. Have you seen an increase in the number of malpractice lawsuits related to care provided solely through telehealth.
Yes. So the CMS just released a report a couple of days ago, where well, first off, there's a lot of fraud, right? Because CMS was reimbursing for audio only visits. And so they got, I think it's an entity in South Dakota. I can send you a link, Carrie, to this report that came out. That's just really fascinating. It was ridiculous how many, they were asking. This particular entity in South Dakota had like thousands of telemedicine encounters, audio only, seeking reimbursement, and they were prescribing durable medical equipment and all this typical fraud stuff. So there's that piece of it, right? And then from a malpractice perspective, it's ginning up through the system, because remember, the expectations are that this is why informed consent is so important, to tell patients there's limitations to a telemedicine encounter. They have to understand what those limitations are. They have to accept the limitations for you to move forward. So but the expectations are that if you treated a patient, the standard of care is the same as if it was, did you, doctor, or did you, provider, feel that you could adequately prescribe or do what you were doing in a telemedicine encounter. And so what I am seeing, and I don't travel in circles as personal injury lawyers. I don't particularly care for that group, but I do know, as part of the different bar associations, that is where they're targeting, because during COVID and during the pandemic, people weren't going to see their physicians in person. They weren't going into the hospital. So the dreaded PI lawyers have to, come up with money somehow. So they're looking at this. So yeah, it's percolating through the system. But I'm hoping that providers were sensible in what they were doing, given the situation that they were in. So yes. It is happening.
Okay.
I have a question. It's just come up so much, and you mentioned it earlier, but is there something someone from a specific state can Google to find more information on the telehealth laws in their specific state? Or is there a national website, and what is that? And what's the best place to start?
I know Kat did address this at the very beginning, and she did say to check your specific board, your medical board, for that information, because, and Kat, feel free to jump in, but it sounds like there is not just one place to go to get information across all the states.
Yeah. So general information, hhs.gov is a really good website for just general rules, guidance on how the HIPAA rules permit covered health entities to, use telehealth encounters, like what's acceptable, what's not. Once again, the Federation of State Medical Boards, FMB, and let me just see if I can find, I'm looking at my phone, I apologize. But yeah, if you Google, I think it's, let me look at if it's Federation of State, hang on, State Medical Boards. Yeah, it is FSMB, Federation of State Medical Boards. They have really good resources for telemedicine. There's also, let me see if it's CM. I can't remember the other one, but yeah, I mean, I would just generally start doing, Google searches, but I do know that the Federation of State Medical Boards is a really good, has really good, I think it's updated every 6 months. And I mentioned this earlier, where it'll list like the states, each state, and then it'll have the rules, but it doesn't, it's specific to, the waivers, like we talked about, like what states have waivers for interstate licensing or so it's not, the FSMB doesn't have like one place that you can go for everything. You have to reach out and look at different things. And that's why I mentioned, talk to the entity that license. So whether it's the medical board, the nursing board, of your particular states. I mean, there's no shortcuts, guys. You got to do the work.
Got to do the work. With that, I know we're at the top of the hour, and Kat, this has been incredible. You've covered so much territory today, and I really think our audience got a lot out of this. I'm sorry we couldn't get
Hope
through all
so.
the questions. There were so many good ones, but please do feel free to follow up with Kat directly. She's been so gracious with her time, and just filled us in on so much good content today. Thank you. And for those of you who may be interested, join us again on October 11th. We are going to be hosting Elation Health and Hint Health, and walking through how new practices or scaling practices can learn how to use Spruce, use a clinical first EHR and membership management and billing software together to streamline operations. So we're going to cover some more great ground. And if that sounds like something you'd like to learn more about, please be sure to join us. Thank you everyone for your time today. I'm so glad you all stuck with us. This was a great session. Thank you again, Kat, and hope we get to have you again soon.
All right. Thanks, everybody. Bye now.
Bye-bye.